as many of you know who are in the audience, military families are required as a feature of their oath that they swear to of allegiance to the United States when they become members of the military to go where the Department of Defense tells them to go. It's also necessary for upward mobility for those who choose the military as a career to move from one state to another and across the world for various promotions and opportunities in association with the duties of these men and women who we value. Unfortunately for their families, there are consequences, not all of which are positive. And one of the possible negative consequences can be the need to transfer between public school districts of one state to another. And the problems that are associated with those kinds of transitions affect military children particularly because they move on average from 6 to 9 times during a career. And so the stage really is set here for the issue that led to the adoption of the Interstate Compact.
Rick?
Yes.
I'm going to stop you for just a second. We are having a couple of people who are saying that they are having difficulty with their audios. Okay, I don't see anyone piping in that they can't hear you now. Rick, will you speak loud and clear for everybody?
All right.
I think we're ready again.
And clearly, I think, with probably a bit of a Kentucky accent, but I can't help that. So hopefully all can hear. Again, we are discussing the Interstate Compact on Educational Opportunity for Military Children that is designed to address the problems that arise from military families who are deployed when they move from one state to another and must transfer their children who are students in grades K through 12 from one public school district to another. And let me just begin discussing how the Interstate Compact seeks to address these problems by telling you a couple of stories, actually based in reality because these are true case scenarios that have arisen during my tenure as the General Counsel for the Interstate Commission. One particular family moved from Illinois to New Jersey as a result of a deployment, and the father was required to move to New Jersey. The son was a transferring senior and was classified as an exceptional student in Illinois, which was the state from which this family moved to New Jersey. His mother began working with the new school, and her son's classes were discussed with the new school in New Jersey and was finalized prior to his enrollment in 2010. As a result of the initial discussions with the school district in New Jersey, the son was required to give up a science class in order to take a required yearly PE and health class, even though he had over 21 credits in PE and health, and only 16 were required to graduate in New Jersey. Nonetheless, this school district and the local school officials said that he had to repeat his PE and health class. They also required, the officials in New Jersey also required that this student repeat a class in personal finance and to take an additional practical arts course, which would have caused him to drop 2 more classes after school had already begun and he had been in session for 3 weeks. He did take a required personal finance class in Illinois, which was the state that he transferred from. The course descriptions of that class in Illinois were virtually identical to the class in New Jersey, with the only exception being that in Illinois it was counted as a half-semester course and New Jersey a full-semester course. He would have achieved 150 credits, which were more than required when he graduated later that year. His parents had requested that the New Jersey School District waive the rest of the personal finance class. If he was required to complete a practical arts class, they also asked that the PE class be waived so it didn't interfere with his core classes or his participation in the band or foreign language. Initially, the school district in New Jersey refused to accommodate this request. However, after receiving a concern from the parents and a complaint from the parents, the commission contacted the school principal in New Jersey explaining what the compact requires, and in this case, in the area of placement and attendance, particular flexibility in some circumstances. As a result, the school was accommodating and agreed to work with the child's parents to allow a waiver of either the PE class or the personal finance class, and it was a choice that the family was permitted to make. Second example, and I'll try to be brief. This case involved a move from the state of Texas to the state of New Jersey, where the military family in question had a student who was a sophomore. The family had had problems with the transfer, mostly involving graduation requirements. And the Virginia school district into which they moved informed them in December of 2010, the year he was to graduate, that he was required to take what Virginia refers to as a standards of learning test, covering materials that he had studied in biology and Algebra 1. He studied for these over Christmas break and took the test, doing well enough to meet the standards. However, he was subsequently informed by his guidance counselor in Virginia that he was only allowed one elective for his junior year because he also needed to take a freshman phys ed class, which he had not completed because he was in a different school district in Texas prior to coming to Virginia. The student had been in the band for 5 years and was also seeking to take a pre-engineering class and really did not want to have to be required to take a PE requirement since he was in marching band and Air Force Junior ROTC, which in Texas had been treated as satisfying the PE requirements. The family understandably felt they were being penalized for moving to the new school, spoke to a guidance counselor who said he had no choice in the matter. Subsequently, after consulting their local school liaison officer, the Commissioner of Virginia was contacted. The national office for the commission took part in discussions with Virginia, and this case was also successfully resolved, with the school district in Fairfax County waiving the requirement that this student take physical education and accepting his credits in the previous state for marching band and junior ROTC. While I had to get into some detail, I think any of you who are school administrators or school liaison officers or parents can identify with the types of administrative issues and the bureaucratic maze that one sometimes has to go through in order to get these cases resolved. And frankly, these two examples are the poster children, so to speak, for why there was a need and continues to be a need for an approach that would allow families to address these problems comprehensively rather than on an ad hoc basis. And so based upon these types of problems, in 2006, the Department of Defense coordinated with the Council of State Governments to draft at that time, new interstate compact in conjunction with a wide variety of federal, state, and local officials, as well as national education stakeholders, including associations of principals, teachers, parents, the National Education Association, the National School Boards Association, and many, many others. Since that time, a compact was drafted and began to be circulated through the legislatures, and at this time I'm pleased to inform those of you who aren't aware of our recent increase in membership that we now have 47 states that have enacted the Interstate Compact on educational opportunity for military children, as well as the District of Columbia. And legislation is pending in New York, Minnesota, as well as New Hampshire, which are the only 3 states which have not yet joined the compact. And it's our hope that these states will join the compact by the end of the current legislative session this year. Among the issues that the compact seeks to resolve include those that you see on this slide. And I mentioned a couple of issues related to this list in the scenarios which I just told you the story about. And other issues including transfer of records, course sequencing, graduation requirements, redundant or missed exit exams or exit testing, end-of-course exams, as well as entrance age variances in kindergarten and on up through grade 12, as well as the power of custodial parents or those acting in the place of parents to act for children in the absence of one or more parents who are deployed. In order to understand how the compact works, now that you are aware and maybe have been aware that 47 states have adopted it, let me just spend a couple of minutes talking about what a compact is. Some of you may not be aware of the legal significance of this form of government regulation because it is unusual, although certainly by no means unprecedented. Simply stated, a compact is an enforceable state statute adopted by each member state choosing to join it. But it is also an agreement among the states who enact the legislation, or which enact the legislation, to engage in the cooperative regulation of the activities that the compact seeks to regulate. In other words, the member states enact a statute in which they agree with each other to regulate the conduct in question on a uniform basis and continue to do that as a collective exercise of the sovereignty of the states. No federal action is required. No act of Congress is required. No action whatsoever is required of the federal government, and in many legislatures, particularly in areas such as education, that's always viewed as a positive, and I think many of us can say the same. So that this is a state-based solution to a problem that is more than just a handshake or an agreement to do good things. It is the state law in every state that has adopted it. These mechanisms are constitutionally recognized under our federal Constitution, and as far back as the original Constitutional Convention, which produced our current Constitution and was ratified in 1789, there has been and continues to be a compact clause in the federal Constitution allowing states to enter into agreements and compacts such as this one that we're discussing today. Among the areas that these compacts regulate, just to let you know that this is not the only compact in the world, there are approximately 200 compacts that have been enacted since 1789. Many of those began as primarily tools to regulate boundary disputes between the early colonies. But in the 20th century, and certainly through the early part of the 21st century, compacts have been increasingly used for regulatory purposes, including areas involving emergency management services, environmental resources such as river basins and other natural resources, multi-state transportation issues, taxation, corrections and public safety, child placement and crime control, and many, many others, too numerous to mention. The other important value to keep in mind is that as a compact, the Interstate Compact on Educational Opportunity for Military Children is one in which all states that have enacted this legislation are bound to observe, including any rules that are developed by the compact. And any state legal provisions that are enacted that would conflict with the provisions of the compact would violate the contract clause of the Constitution, preventing contracts, including those between states, from being impaired by any signatory, and by the compact clause of the Constitution, which I mentioned earlier. So being educated now about this wondrous instrument called an Interstate Compact, and I hope you're not asleep yet, let's talk about the exciting part. How does this compact work, and to whom does it apply? First of all, the compact applies to the children of active duty members of the uniformed services. That includes members of the National Guard and Reserve who are under active duty orders. It also applies to members or veterans of the uniformed services who have been severely injured, medically discharged, or retired for a period of 1 year after medical discharge or retirement, and members of uniformed services who die on active duty as a result of injuries sustained while on active duty for a period of 1 year after death. The compact does not apply to inactive members of the National Guard or Military Reserve. Does not apply to members of the uniformed services who are now retired and not covered by the 1 year period above, or veterans not covered by the one-year period mentioned previously, and other U.S. Defense Department personnel who are classified as civilian agency employees as opposed to active duty members. The compact seeks to deal with those areas in which children of military members in grades K through 12 are typically likely to engage or suffer from in their moves from one state to another. You might ask, how did we obtain information and who gathered it to decide that these were the areas that required and deserved the most attention? This was based on a study commissioned by the U.S. Department of Defense by the Johns Hopkins University, which was appropriately and statistically correctly done, in which military families, school districts, and a host of other officials were interviewed, and research was done revealing that there are 4 primary areas where military children and their families are likely to experience transition problems when they're transferring from one state to another. Those 4 areas are on the slide that you see before you now: enrollment, eligibility, placement, and graduation. Let's take these quickly and talk about each of them briefly. Enrollment. And you see here several of the areas under that topic which the compact seeks to resolve issues that frequently arise. One being educational records. It's frequently the case that families transferring from one public school district to another will encounter problems with the lack of a certified record, so that the new school district into which the family is moving in the new state will not allow the child to enroll because they don't have an original or a certified copy of the educational records. The compact says you don't need it. You do not need it in order to initially enroll. You can provide a photostatic copy of the enrollment records, and then the sending state is obligated within 10 days to follow up with a copy of the certified record, but it does not permit delaying enrollment simply because you don't have the required certification at the get-go. There's also provisions for immunizations and age of enrollment issues to be addressed through the compact on a consistent basis. Eligibility involves such things as activities involving both academic and extracurricular activities. For example, there have been cases where a student who had a 4-point average was not permitted to join the Beta Club or National Honor Society because they weren't in the school district in time to attend the induction ceremony in order to participate in those activities. The compact provides that if a student is otherwise eligible to participate in such activities, they should be given the opportunity to do so, and that the school district should reasonably facilitate an opportunity for that child or that student to participate in the extracurricular activity, both academic and recreational, including sports, although clearly the compact does not exercise control over private athletic associations that are not part of the school district. Placement involves the issues that include the 2 scenarios that were mentioned at the beginning of the presentation. Frequently, we have issues that arise in the receiving state school district in deciding whether a course taken in the previous state qualifies for credit in the new school district. Obviously, auditors are reviewing those situations to make sure that placement is appropriate, but the compact presumes and requires that the member states presume that the placement decision that was made in the prior state is the correct one, and to enroll the child at the level where they were in the prior state, but does not foreclose the new state or the receiving state from doing independent testing and appropriate testing to make sure that the placement is correct, and does not prevent later alteration of that based on testing revealing that there should be a different placement. With respect to graduation, and I've skipped over that one, graduation involves one of the most important aspects of the compact because on-time graduation is so important to students who want to be able to graduate with their classmates. The compact provides that receiving states should make all possible accommodations, including consideration of waiver of exit exams or end-of-course exams or graduation exams if there is another normative test that can be accepted in lieu of a state-sponsored exam. We ask the states to consider that. Certainly, there are situations in which states don't feel that those exams can be waived, and if that is the case, the compact requires that the receiving state into which the family has moved cooperate with the previous state in which the family lived to see if a diploma can be obtained on time and the student can graduate in the prior state or receive a prior diploma, a diploma from the prior state if the course requirements and other graduation requirements have been met. We have particular provisions in the compact related to both exceptional children and special education services. I've put some language on the slide here that is a summary of the compact provisions in that area, and you can see that the compact certainly refers to and incorporates by reference the requirements of IDEA and requires, as does IDEA, that the receiving state shall initially provide comparable services to a student with disabilities based on the current IEP and complying with 504 of the Rehabilitation Act and the ADA. Obviously, we always encounter or sometimes encounter problems with determining what constitutes a comparable service. And while the compact certainly does not seek to take the place of officials in each state that are charged with the enforcement and implementation of IDEA, as with all other educational programs, the compact requires that accommodations be consistent with those that are required under federal law. And I have already referred to the graduation issues, which the compact encourages waivers, including exit exams for those transferring during senior years, if that's possible. The compact operates on the basis of interstate adoption of the statute by the member states. However, within each state that is a member of the compact, there is a state-based organization called the State Council, which consists of stakeholders as well as representatives of the executive branch, the legislative branch, and the education officials who most of the time take part in the administration of the compact, so that state issues where particular problems are being encountered by military families in a particular state can be addressed and brought to the attention of that state's commissioner to the National Commission. And each member state of the Interstate Commission has a representative that is to be designated by the member state to attend meetings of the Interstate Commission that administers this compact and for which I provide legal representation. We meet many times telephonically and electronically, but at least once each year there is a face-to-face meeting of all of the commissioners, at which time issues that are problematic as well as success stories and continuing education, orientation, and other exchange of ideas and best practices occurs at our annual meetings. These are public and anyone is welcome to attend, but all of the commissioners from the states that are members, which are 47 now, well actually 48 with the District of Columbia, are there as representatives of their states and engage in all of those activities, including rulemaking or enforcement if necessary. And that's important to emphasize as well, because this is a state law. Like any other state law, it is enforceable. And the Interstate Commission, which is a legally recognized administrative body created by the member states, has the authority to intervene and engage in active enforcement of the compact if there are violations of the Interstate Compact by member states. The National Commission does have the authority to engage in limited rulemaking based on the provisions of the statute and can carry out its objectives in these ways at a national level. I want to leave time for questions, and I think we have some time remaining, and I hope that we get the opportunity to discuss some of these questions that you may have on the phone today. If you are not able to get your question addressed and we run out of time, my contact information is on the slide, and I would be more than happy to address with you any questions that you have. Let me call your attention, though, to the Commission's website, which is also available for resource information and contact through our National Commission, and you can find that at www.militarycompact.org. And we will try to circulate that and give you some opportunities to engage the National Commission if you have questions after the conference. We have a wide variety of educational materials, training materials, and written pamphlets giving information about what the compact is and what it's designed to do, and those are available in most cases so that they are downloadable to each of you for use either individually or in your discussions with your colleagues concerning issues pertaining to military families who must move. Heather, I'm going to pass the baton back to you and would be happy to address any questions.
Thank you, Rick. There is one so far, and that one is, it's K through 12, but what about children who have disabilities who are in birth to 3 programs and receiving services under an IFSP, Individual Family Service Plan with IDEA, or those who are 3 to 5 who are in school-based preschools under IDEA Part B?
We only deal with students in grades K through 12 and only those students who are enrolled in a public school. That would include such institutions as charter schools if they are classified under state law as a public school. But if it's not classified under state law as a public school and is rather a private school or a home school, the compact would not apply.
Okay, so even though they are in public schools and covered under the IDEA, they aren't covered under the compact.
Yeah, that's correct. The compact does not seek to supplant the requirements of IDEA, and it is specifically worded in such a way that only students in grades K through 12 are covered. Certainly, the federal law would trump any conflicting statute at the state level, including the compact, and so we're not attempting to supplant that, but certainly would expect that requirements that are applicable to students in grades K through 12 are met.
Terrific. Thank you. All right. Is there a method that the information re the Interstate Compact can be disseminated to military family members?
We are in the process of working on getting information to those who need it best, and Department of Defense has been a partner in this effort, working with the military community through the school liaison officers, through other private organizations such as IMSEC and other military family associations. There are opportunities for comment at the website if those of you who need to access your state commissioner, if you can't find your state commissioner within your state, you can contact our National Commission, and we'll be glad to direct you to the commissioner in your state for information or concerns that you have about problems being encountered with any public school district in the state.
Excellent. It says here, public schools are obligated to educate students during the transition period. Does the compact cover it?
I'm not sure I understand the question.
Okay, well, hopefully the individual can put some more detail in there for us. And in the meantime, another question, is there any responsibility for the State Department of Ed or other agency to educate school administrators on this topic? I, as a school liaison, am educating, but wonder who has the most weight to enforce it.
Certainly the Department of Education is a principal player in every state. As an agency of a state, if the state has enacted the compact, and in 47 states that is the case, the Department of Education, just like every other agency, is bound to abide by and enforce the law. Obviously, reasonable minds can differ as to how the compact might be interpreted or applied. And when there are problems in that area, the Commission frequently engages in some interaction with both military families, school liaison officers, and Department of Education officials attempting to provide information. On an ongoing basis, however, the questioner is quite correct. We think the best way for families and individuals to encounter consistency is to make sure that we're on the same page in both the military community and the education community. And we are engaged in outreach efforts on the part of the National Commission to accomplish that. As you can tell, we've been sort of building this airplane while we're flying it, so to speak, in the effort to get all the states on board. But we are reaching out, and I and others associated with the Commission have been making appearances at the invitation of such groups as IMSEC, the National Conference of State Education Attorneys. I've met with national associations of officials with state disability. With special needs and disabled children to deal with these issues on a nationwide basis, so that individuals in the various state departments, including the Departments of Education and their legal advisors, have some ability to interact with us and can resolve these questions as they come up. Certainly, it's not a perfect system yet and never will be perfect, but we keep aiming for increasing consistency and perfection, and we want to get as close as we can.
Okay. Can you talk more about how the compact can help students when it comes to sports?
There are several states that actually place the responsibility for high school athletics under the control of, and I mean that regulatorily and legally, the Department of Education. However, that's a minority of states. In fact, less than a half dozen states are organized that way. The vast majority of states, probably unfortunately to some extent for our purposes, have independent organizations of high school athletic associations which don't answer directly to the State Department of Education. Unfortunately, because this is the case, the compact can't be directly enforced against them. On the other hand, school officials who run the athletic programs and fund them do have some obligation to do everything that they are able to do, including encouraging state high school athletic associations to seek to accommodate needs of athletes who want to participate. Obviously, if you're a 7-foot basketball star or a 250-pound linebacker who knows how to break any offensive or defensive line, you're probably going to make the team just because of your prowess. But for many kids, that's not the case. So we want to make sure if you're qualified, even though you're not a superstar, you get the opportunity to participate if at all possible. One of the ongoing efforts that we are just in the initial stages of is outreach to the organization which represents the state high school athletic associations. and like other groups throughout the country, there is a national association of high school athletic associations, and it's our belief that this group will not turn a deaf ear toward issues pertaining to accommodating military children, but I can't tell you yet that those efforts have gone far enough to give you any specific direction as to where we might go now. But certainly if we have issues involving athletic participation, there is a requirement that state officials do what they can to facilitate opportunities to participate. And anything further, the Commission has been involved in a number of cases in trying to offer encouragement, interpretation, and support of obligations under the compact.
Okay. Next question is, how are the number of absences dealt with during deployment? Parents have taken up to 1 month before re-registering students in school.
Deployment-related absences are an area that the compact seeks to regulate, and we do have a specific article within the compact attempting to provide for increased absences where necessary as a result of deployment activities. And a student whose parent or legal guardian is an active duty member of the uniformed services who has been called to duty, is on leave from or immediately returned from deployment to a combat zone or combat support posting is required to be granted additional excused absences, although the local education agency superintendent, who would be the school superintendent, has discretion on how many excused absences to allow. So the compact specifically speaks to this issue under Article 5 of the compact statute, and if your state is a member, and most states are, that would be an area where absences should be permitted.
Okay. Next question. The compact covers students K through 12. Does this include students with disabilities who are ages 18 through 21 but have not yet graduated?
We don't define the enrollment period by age. So I would say at this point, as long as a student is enrolled in grades K through 12 and is the child of a military member as defined by the compact, that they would probably be covered.
Thank you. Okay. Heather, who is a school liaison officer, says, I would like to further discuss absences related to deployment activities. The compact allows flexibility for additional excused absences to visit the parent or legal guardian due to deployment. However, it appears the LEA can make the determination. For example, I have a school district that says that absences due to deployment will fall into the unexcused category because 10 are allowed per semester. Can this be disputed?
Well, let me say this, and I want to be careful here because I might wind up having to become involved in a question like this since it relates to a specific case. But in general, the compact requires that discretion be exercised by the superintendent, but the wording of the statute is such that it would seem to me that if 10 is the requirement for everyone and that no special dispensation has been granted or there is no existing criteria for granting absences in excess of 10, that the compact certainly imposes an obligation for the LEA superintendent to consult with the parent or legal guardian and attempt to accommodate such a request. And simply saying, no, we only allow 10 for anyone, I don't think constitutes a good faith effort. Now, whether we can say there's some legal standard by which at this point that superintendent can be forced legally to grant the number of absences that the family requests, I'm not going to go that far, but certainly I think the compact imposes a duty of good faith on all school officials to make consideration for a particular situation.
Okay. What if your district has elementary magnet schools? In this particular one, there are 2 schools that are always at capacity, so when families come in, they do not have a chance to go there. Since the district never knows what grade level incoming students are in, it would be impossible to hold a place. Any suggestions?
Yeah, that's a tough one. Obviously, we want to provide equal opportunities without becoming a special privileges for military kids compact, and where you draw that line is tough. But certainly, making a request in advance and doing everything possible to get on any list or other waiting schedule along with other students it should be encouraged. Whether or not you would create a special place for a military child that wouldn't be available to any other child, then I think you're getting into an area where we have to tread carefully. So again, without wanting to get any more specific than that, because again, some of these cases may wind up on my desk as an official matter that the Commission's being asked to look into, I would say all reasonable effort should be accommodated, but that would fall short of creating some special place in line or allowing somebody to cut line simply because they're a student of a military family. But certainly advance registration or getting on a list seems to me to be a reasonable request.
Okay, thank you. I'm just checking to see if we have any other questions here. Are there additional questions that anyone has? The question is, are there typical special education issues the Commission has seen across the years that we want to be aware of?
I think primarily what I made some passing reference to in terms of what constitutes a comparable IEP is a frequently encountered problem for military families as well as school officials. And while we don't seek to supplant the federal legislation, we do seek to encourage school districts to make sure they understand what their obligations are under the law, and in some cases the Commission's been called upon to simply intervene to the extent of asking local officials if they have contacted their state individual who may be more informed either in the education department or in the area that regulates special education needs, and sometimes just connecting people, including local officials, with those who are in a position to make the judgments and know what the legal requirements are is enough to satisfy the problem. I do think there is some potential for the compact to provide some means of mediated settlements that can be achieved between state officials and individual students and their families, and certainly no one believes that litigation is the best solution, although that's the ultimate way that problems get solved under IDEA. But that can be costly, time-consuming, and in the end, nobody wins. So certainly if we can bring people together to sit down and reason with one another, that's the best approach, and we seek to do that.
Okay. Additional question, does the National Commission look, since they do look at rulemaking, is there any chance that they would be looking at the potential for helping those families who have children birth to 3 or 3 to 5 who have an IEP or an IFSP?
I wish that were the case, but unfortunately, because the statute defines the eligibility and applicability and does so in a very specific manner in which specifically those in kindergarten through grade 12 are the only students for which we're authorized to act, a rule would not be permitted to be adopted that goes beyond what the legislatures have allowed in the statute. So in order to accomplish that, essentially what would have to be done would be the legislatures of all member states, since it's a compact as well as a contract between the states, would have to amend their statute to include additional age levels.
So there is a question. It says, I do not understand why ages 0 through 5 are not included under the compact. Why were they left out in the first place?
Well, that's a good question, and I don't know that I can give you the complete answer, although I was certainly involved in some of the drafting. We were trying to gain coverage for as many students as possible that are actually in the education system, and obviously at the time the compact was drafted in 2006, there were not as many preschool programs and other programs that were being emphasized throughout the country for younger ages. And so kindergarten was determined to be the place to start through grade 12, and that would include the vast majority of military families and problems encountered by those children. It's possible that some effort might be initiated in order to expand that, but again, that would have to be through legislation rather than rulemaking. Okay,
so the best approach on those children birth through 5 or birth to 5 would be that they check their state rules with regards to anything. Most of them would be, once they met the criteria for IDEA under Part B, they would have to be provided preschool services, and hopefully the receiving district would accept and implement that IEP to the extent comparable.
I think that's right, and again, I think one of the other reasons why perhaps those students were not included is because there already is federal law, namely the IDEA, which applies to those particular students. But that's as much as I can provide in the way of legislative history, so to speak.
Okay, thank you. Are there any additional questions that anyone has? I don't see any at this time. Rick, we appreciate your time and all that you have done. This has been very informative, and we want to thank everyone who has attended. It is wonderful to see that people are this interested in the Interstate Compact and what it will do for our military children across the nation. And so thank you very much, Rick.
Yeah, one other point before we go, Heather.
Yes.
I think I did not give our new website address for the Commission. It's www.mic3.net.
Thank you. MIC3.
.net, yes.
Okay. We will make sure and let people know that. And we want to thank you again for all of your help, and look forward to talking with you again soon. So thanks to everybody.
Thanks, Heather, and everyone else. Have a good day.
Have a good day, too. Bye.